Welcome back to our courtroom breakdown. Today, we've got a case that mixes high-stakes felony charges, probation violations, and shocking revelations in the witness stand. From marijuana use linked to medical conditions to aggravated assault charges, this case keeps the tension high. Stick around as we dissect every critical moment and the legal strategies in play. You won't want to miss how these courtroom decisions could dramatically alter the lives involved.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Give me just a second to get that pulled up.
Our agreement, Your Honor, is for her to be on special needs safety.
Thank you. Sorry, it's taking a minute for my computer to get pulled up here. Okay, so Ms. Williford, in cause number 24, DCCR.
Notice here how the agreement focuses on specialized probation programs. This isn't just a slap on the wrist probation with a special needs program, means the court is trying to balance punishment with rehabilitation. It's an opportunity for the defendant to prove commitment to change, but failing this could have severe consequences. Do you think probation really helps prevent future offenses?
1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that...
We've agreed to go on counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true?
Here's the tension. Failed drug tests can trigger probation revocation. Legally, the court is strict because repeated violations undermine the trust and rehabilitation process. The stakes are high. Admitting to these counts isn't just paperwork. It could lead to jail time. How would you handle being on probation with such serious conditions?
True or not true? And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow this agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today. And is that the recommendation from probation as well?
Yes, ma'am.
Okay. I am inclined.
Here's the tension. Failed drug tests can trigger probation revocation. Legally, the court is strict because repeated violations undermine the trust and rehabilitation process. The stakes are high. Admitting to these counts isn't just paperwork. It could lead to jail time. How would you handle being on probation with such serious conditions?
Mind if I follow this agreement to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
There you go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. Looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do.
Notice the intensity here. The judge explicitly warns there will not be a third chance. Probation, extensions, and special programs are serious. This is a pivotal moment where the defendant must internalize the consequences. The legal system is giving support, but it also draws a clear line across it, and the maximum sentence looms. How much responsibility should fall on the defendant versus the system?
You're going to be back in here, and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had a statement prepared for you, explaining the real reason I was doing marijuana at the time was because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden good soul that I will never touch the shit again if you let me go home.
Are you seriously going to stand here and talk like that?
No, ma'am. I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I'd get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that. I was trying to...
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to...
Emotionally charged moments like these show the human side of the courtroom. Fear, regret, and anxiety are evident, while legally the facts matter more than emotions. Observing the defendant's demeanor gives insight into credibility and intent. The plea discussions here are layered legal strategy meets raw human reaction.
Speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now.
I'm so sorry.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff. And figure out whatever to do on that state jail later. All right, sir, you're John Jones.
Yes, ma'am.
Give me just a second. Let me get your everything pulled up here. Let's see, Mr. Jones, in cause number 25 DCCR 0523, you're charged with a first-degree felony offense of murder from April 28th of 2025.
New developments this morning in yesterday's deadly shooting in Beaumont. Police say they're looking for these two 17-year-olds. Take a good look at your screen. This is
Now we switch focus to a first-degree felony murder case. The stakes couldn't be higher. Potential life imprisonment, multiple charges across different dates complicate the case, and the concept of cumulative sentencing is crucial here. The audience should note rejecting a plea deal at this stage is a huge gamble. Would you risk a trial with such life-altering consequences?
Trevor Green and John Jones. They want to talk to them in connection to the shooting at the Landmark Apartments on French Road. Investigators say a man was gunned down at the complex around 5:30 p.m. He was rushed to the hospital where he later died. Officials haven't identified the victim or a possible motive, but Officer Haley Morrow says Jones has an active felony warrant for unauthorized use of a vehicle from an unrelated incident. She also says anyone living in or around the Landmark Apartments should check their camera footage as police gather evidence.
Our detectives are also asking anyone from East Tex and French all the way to French and Delaware, anyone along French Road essentially, to check their surveillance cameras around this time from about 5:46 to 6:15.
Here's another look at the two people that police want to talk to. That's Trevor Green and John Jones, both 17. If you know where they could be or have any information, call Beaumont Police or Crime Stoppers.
And what that means, sir, is that if you go to trial and you're found guilty in that offense, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand the range of punishment?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged with the state jail felony offense of unauthorized use of a vehicle from October 15th of 2024. What that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in the state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1352, you're charged with a first-degree felony offense of aggravated robbery from September 18th of 2024. What that means in that case is if you go to trial and you're found guilty, the range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then finally, in clause number 25, DCCR 1353, you're charged with the second-degree felony offense of robbery from September 18th of 2024. And in that case, what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then I have here on the tablet in those cases some plea bargain rejections that you've signed with Mr. Wilkerson. They show that the district attorney's office has made an offer if you wanted to enter pleas of guilty for a 35-year term in the murder case to run concurrently with a 35-year term in the aggravated robbery case with a dismissal in the robbery as well as the state jail felony unauthorized use. Is that correct?
Yes, ma'am.
Do you understand what their offer is?
Yes, ma'am.
And have you gone over it with Mr. Wilkerson?
Yes, ma'am.
And do you want to reject that offer and have all 4 of your cases set for trial?
Yes, ma'am.
All right. Is there any reason to expect that those offers would change any evidence that you're waiting on that you guys haven't received or gone over?
No, Your Honor, not at all. In fact, the state will likely be filing a motion to accumulate the sentences to the extent that we can. I think 3 of them come out of one occurrence, and then there's one from a separate occurrence.
You've actually got 3 different dates. So you've got ag robbery and robbery from September of 2024. You've got an unauthorized use from October of 2024, and then the murders from April of 2025.
To the extent we can accumulate all of those, Judge, we will seek to do so.
So I want to make sure you understand, Mr. Jones, that if you are found guilty in more than one of these offenses by a jury, the state can file requests that I stack or run cumulative, which means stack on top of each other any punishment that you receive. Do you?
Cumulative sentencing is a major legal tool here. The court can stack punishments, meaning each conviction adds years on top of the previous one. This elevates the pressure on defendants to seriously consider plea deals versus trials. It's a high-stakes chess match between the defense and prosecution. Who do you think would have the upper hand strategically?
Understand that as well.
Yes, ma'am.
And that after today, I will not accept this agreement for a 35-year term. If you change your mind later, you can enter a plea open to the court. You can enter a plea to something different, but it's not going to be 35 years. Do you understand?
Yes,
All right. And do you want to have all of your cases set for trial?
yes, ma'am. I got a question though.
Yes, sir.
Like, it's my offer 35, right? Like that's what the DA's offer, right?
Uh-huh.
My co-defendant admitted to it, but he got a 30-year off.
Here's the thing. Your offer is what your offer is. He may or may not have had the robberies before he would, listen, I don't know. I know the offer is what the offer is. All right? So either you take the offer or you go to trial and let a jury decide.
This is where negotiation nuances come into play. The defendant compares offers for co-defendants, highlighting perceived fairness or disparity. But as the judge clarifies, each case's unique prior, criminal history, charges, and circumstances influence offers. Legal audiences should note, perception of unfairness doesn't invalidate an offer, but it can influence strategy.
I'm not involved in negotiations. I'm not going to tell the district attorney's office what to do. That's not my job. But you don't get to, everybody has different issues in their cases that they feel important and why they would make different offers for different co-defendants. All right? So you're not going to have a different offer, and that's what I want to make sure you understand. Even though there was something different for your co-defendant, the district attorney's office has said, this is it, this is your offer. Do you understand?
Yes, ma'am.
Okay, and you want to reject it and go to trial.
Yes, ma'am.
Okay, we'll get it set for trial, and Mr. Wilkerson will begin preparation. You can go back with the bailiff. All right, sir, you are Elazar Stansberry?
Yes, ma'am.
And Mr. Stansberry has been charged with the offense of murder.
Well, developing tonight, a 26-year-old man has been charged with murder after a shooting Friday night at an apartment complex in Beaumont. Police say it happened around 7:15 at 2317 Broadway Street.
Introducing Mr. Stanberry, now facing a murder charge. $5 million reflects the court weighing community safety against presumption of innocence. Attorneys argue mitigating factors like cooperation and family ties. This is a masterclass in bond hearings, balancing public safety with defendant rights.
Good evening, I'm Ebony Coleman. When they arrived, officers found 33-year-old Clarence Rosamore had been shot. He was taken to a Southeast Texas hospital where he later died. Officers detained 26-year-old Elazar Stansberry at that complex, and he was taken to the Jefferson County Jail and booked on a murder charge. A bond amount of $1.5 million has been set, and he must remain in Jefferson County as a condition of that bond. We'll keep you updated as we learn more.
The case has been filed and not indicted yet. Mr. Burbank was appointed to represent Mr. Stansberry. Ms. Holmes has joined in just with regard to filing an application for writ of habeas corpus seeking a bail reduction. And so we set it for this hearing. Mr. Stansberry's bond is currently set at $1.5 million. And Ms. Holmes, you may proceed.
Thank you, Your Honor. Your Honor, I guess in regards to the case, we have limited information. All we have at this point is a PC affidavit, which is kind of generalized. I have met with Mr. Stansberry in regards to the allegation, and we do believe once we provide a packet, possibly once this case reaches the district attorney's office for the grand jury to review, then there may or may not be an indictment. We don't know at this point. Mr. Stansberry has been in custody since November 7th. I did meet with the intake division on yesterday. They do not have the case received at the district attorney's office at this point. It is still with the police department. And so we do not have a timeline on when this case may possibly come to the district attorney's office. Your Honor, Mr. Stansberry, with the current bond amount, we do believe that it is excessive in looking at the other individuals who are currently incarcerated. Mr. Stansberry has the highest bond at the jail, him and one other inmate. And looking at other individuals at the jail, especially those who have murder charges that are not indicted at this point, their bonds currently range from $250,000 to $350,000, and I do have those names if the court needs those. Your Honor, we are asking that in light of this, that Mr. Stansberry bond be reduced to a reasonable amount. He does have family here who will make sure that they secure his presence. Just briefly, although we don't have all the information, I can say from what I do know that in regards to this particular case, Mr. Stansberry did not flee. He's actually the one who called 911 after this had occurred. He was cooperative with law enforcement and providing his statement of events and everything that happened. So I do believe that that is a mitigating factor for the court to put into consideration, that we do not believe that he will be a flight risk if the court reduces his bond to a reasonable amount to allow him to bond out. Since this has occurred, Mr. Stansberry has lived in the area since 2020, in which he was relocated from a hurricane, in which he moved with, at the time, with his children, who do reside here in Beaumont with their mother, in which they share joint custody. Since this has occurred, Mr. Stansberry has lost that apartment, where this occurred at his apartment. If he is allowed to bond out, he does plan, or is in hopes of planning, to live with his
Bond hearings often delve into personal history. Here, housing, family, and stability play a huge role. The court examines whether releasing the defendant jeopardizes public safety or flight risk.
His current girlfriend, who's here as well with his parents, she lives at 25419 Richton Falls Drive in Richmond, Texas. And that is where he hopes that he will be able to reside if allowed to be released out on bond. Both of his parents are here. They're residents of Louisiana. His father resides in Lake Charles. His mother resides in New Iberia. But Mr. Stansberry does hope to be allowed to stay at the home in Richmond, Texas, since he doesn't have any ties to Beaumont except for his children at this point.
What's girlfriend's name?
Jazzy Starks.
Does Starks have any criminal history?
No, she does not.
Okay. All right, anything else?
And Mr. Stansberg also, he does not have any felony conviction history as well, Your Honor.
Okay. All right, thank you. Ms. Malfino?
Judge, I had the opportunity this morning to speak briefly with Detective Jackson. Obviously, he is not here this morning. If the court would like to hear from him, I would ask your consideration, because we have one more docket. If you would like to hear from him in person, if we could maybe hold on this until next week before any substantial reduction of this bond were to be made. I went with Ms. Holmes and we both visited with intake yesterday. We're both aware of the situation that the case has not been brought in, although a warrant was walked through based on the facts they had at the time of the offense. I have brought that to the attention of the detective, not knowing if the case will actually fall in this court next door to whom it will be assigned. I have very limited amount of information, but I did make it very clear to Beaumont Police Department, and they were very receptive to the fact that this case, even if it is absent some of the documentation, such as the phone download that the detective mentioned, it needs to be brought sooner rather than later to the district attorney's office, in all fairness to the defendant. But as the court has very limited information about the facts, I think there is going to be a dispute with respect to an affirmative defense versus an intentional and knowing murder. I don't disagree with that. I think the sides are not in the same position right now, but it's kind of hard to read between the lines with a 3-sentence probable cause affidavit. I think based on what this court has done recently, and based on, Judge, just on the fact that every single weekend we turn on the TV and there's a murder in Jefferson County, I think that bonds in this county to protect this community, understanding of the defendant's rights, need to be substantially more than they have been in the past. And I think the court is beginning to follow, at least this court, is that trend. I'm not saying that an amount of relief is necessarily opposed by the state, but I don't believe, just based on what I know, Judge, and based on everything we're dealing with in this community, that something as low as $200,000 would be sufficient at this point.
My biggest concern at this point is the fact that this is from November 7th and you guys don't have it yet. And I think obviously the nature of the offense is we're tired of hearing about these offenses. It's the worst offense we can have. However, I mean, everybody has.
Notice the tension between the timing of charges and the right to a speedy process. The defendant has been in custody for weeks without indictment. Legally, that raises serious procedural questions. It's a delicate balance between protecting society and upholding individual rights.